The Ira Smith team family hopes that you and your family members are remaining secure, healthy, and well-balanced. Our hearts go out to every person that has been affected either via misfortune or inconvenience. The Ira Smith team is absolutely operational, and both Ira as well as Brandon Smith are right here for a telephone appointment, conference calls, and also virtual meetings. Stay healthy and safe, everybody. I hope you enjoy this Redwater Alberta News, Brandon's blog. Redwater Alberta News. $1.7 billion to clean up orphaned wells due to COVID-19. Introduction. When it went insolvent in 2015, Redwater Energy Corp. might have been a small business with only 19 generating wells and 90 dormant wells. However, a relatively small oil producer was responsible for a huge Supreme Court of Canada decision. Basically, the SCC decided in the Redwater Alberta case that if a business goes belly up, its environmental obligation needs to be paid before secured creditors. I have written before on the Alberta court's decisions and the SCC decision. As a result of COVID-19, the Canadian government just announced a $1.7 billion fund to create jobs in the Canadian oil patch. Redwater Alberta History of Cases. In my previous blogs, I described the Alberta court decisions. The Alberta courts concurred with the receiver and held that the regulator's enforcement activities to force Redwater's adherence to its previously agreed requirements to clean up and permanently cap its oil sites in bankruptcy was not enforceable. The court stated that given the bankruptcy of the company, in addition to a receivership, the Bankruptcy and Insolvency Act Canada took paramountcy over the provincial law. The provincial court said that the BIA took paramountcy because it, 1, allowed the receiver protection from the promises of Redwater Alberta as the licensee in connection with the Redwater properties disclaimed by the receiver/trustee. 2, the priority for the distribution of a bankrupt's assets is regulated under the BIA, not provincial legislation. If the provable claim of the regulator, an unsecured creditor, was paid in advance of the claims of Redwater's secured creditors, that would not be the regime laid out in the BIA. The SCC decision. In the SCC 5-2 judgment, in the Orphan Well Association versus Grant Thornton Limited case, the SCC ruled that financially troubled companies like Redwater Alberta can no longer disclaim or merely bow out of properties they don't want. In this situation, non-producing oil wells, when abandoned or orphaned, leave the resulting ecological cleaning to Alberta's Orphan Well Association. It is a non-profit operating for the Alberta Energy Regulator. What the SCC decision in the case of the Redwater Alberta receivership means is that the costs of properly and permanently sealing an oil well that is to be abandoned is a first-ranking charge against the producer's assets. In the Redwater case, the receiver had to turn over the proceeds, about $600,000, from the asset sales to the Alberta regulator. There was absolutely nothing left for any other creditor, either secured or unsecured. The case was obviously difficult and contentious, given that it was a 5-2 decision and not unanimous. The majority decision stated that the regulator's use of its provincial powers is not in conflict with the BIA. The BIA deals with the personal liability of receivers and trustees and does not let a trustee ignore the environmental liabilities of the estate. The regulator is not asserting any claims provable in the bankruptcy. There is no attempt by the regulator to upset the scheme of priorities stipulated by the BIA. There is not a conflict by the regulator tagging the Redwater Alberta receiver as a licensee under Alberta legislation. The Supreme Court decision goes on to say that the rules cannot be ignored just because there is a bankruptcy. Insolvency professionals must abide by valid provincial laws in administering corporate bankruptcy. It also found that receivers and trustees must conform with non-financial requirements the insolvent company must still adhere to that do not create a provable claim in the insolvency administration, and adhere to the parts of the provincial legislation that does not go against the BIA, notwithstanding that it might prove harmful to the position of one or more groups of creditors. COVID-19 and orphaned wells. Near the end of March 2020, Finance Minister Bill Morneau said that help for the oil and gas industry would be announced. This industry has been hit by two different factors. One, reduced demand due to people self-quarantining because of COVID-19 and therefore there is less demand for oil and gas. Two, the price battle between Russia and Saudi Arabia. Oil on the world market is at an all-time low. At one point, a barrel of Canadian oil was selling for less than $5. The industry cannot operate with oil prices that low. As a result, there have been massive job losses in British Columbia, Saskatchewan, and Alberta oil patches. As well, the regulators do not have the money to reclaim and permanently seal off the abandoned orphaned wells. It is currently estimated that the total cost would be in the $8 billion range. On Friday, April 17, Prime Minister Justin Trudeau announced that the federal government will invest at least $1.7 billion to the orphaned well cleanup. The money is to be used to create oil patch jobs to allow for the environmental cleanup. So COVID-19 or coronavirus has forced the Canadian government to create this support for the Canadian oil and gas industry. It will create jobs badly needed and allow for the cleanup of some orphaned oil wells. Details of the support package have not been released. Presumably, the legislation will have to be drafted and passed in the House of Commons. No doubt more information will be coming out in the coming days or weeks. The Ira Smith team is absolutely operational, and both Ira as well as Brandon Smith are right here for a telephone appointment, conference calls, and also virtual meetings. Stay healthy and safe, everybody.